Good afternoon. Thanks to everyone for joining and welcome to today's webinar, USCIS Fee Increases, What Immigration Professionals Need to Know to Plan and Budget, presented by BAL in conjunction with BAL Community. During the presentation, all participants will be in listen-only mode. If you have a question during the presentation, you may submit it at any time via the Q&A button located in the menu bar on the right side of your screen. Simply navigate to the Q&A section, click on the Ask a Question button, and type your question in the window and hit Submit. An email containing a link to the slides and on-demand recording of this session will go out within 24 hours of the webinar start time. And finally, at the end of the webinar, we would appreciate you letting us know how we did via the survey section on the right side of your screen. We value your feedback as it shapes how we provide you with updates that are most relevant to you. And now it's my pleasure to introduce you to today's speakers. Kelly Deaning is partner in the San Francisco office of BAL. She joined BAL after a 17-year career with USCIS and INS, where she headed the agency's legal strategies in the Western US. Kelly currently leads BAL's I-9 practice, advising clients on immigration compliance and program strategy. Amy Leiter is a partner in BAL's Santa Clara, California office. She works with high-volume corporate clients to craft long-term immigration solutions that ensure mobility of executives, managers, and specialized knowledge workers in an unpredictable environment. She handles extraordinary ability cases for scientists and researchers and focuses on leveraging technology to improve the quality and delivery of legal services. Eileen Lohman is a senior associate in the Washington, D.C. office of BAL. As part of the government strategies team, she analyzes legislative and policy developments in immigration law. She also advises clients on various compliance issues, including I-9 and E-Verify obligations, and assists clients in performing audits of their immigration programs. Lyndon Melman is a partner in BAL's Washington, D.C. office as well, and leads the firm's government strategies team. He counsels corporate clients on complex immigration matters, assists businesses in establishing and managing global immigration programs, and represents businesses in conjunction with audits and investigations by the federal government. He works regularly with the U.S. Congress, the White House, and federal immigration agencies on policy issues. And now it's my pleasure to turn things over to Amy.
Thanks so much, Lexi. We are really excited to talk to everybody today about this very current topic. We're obviously talking about a brand new rule right now, just announced on January 4th. And in fact, it's not yet even in effect, just a proposed rule. So I think the first question to tackle is, what should we know right at the outset? So any big changes here, Eileen, that we should start with?
Yes, thank you, Amy. USCIS is proposing to increase immigration filing fees for benefit requests by a weighted average of 40%. We'll get more into the numbers shortly, but that average does not capture the extent of the increases for business filings. In terms of the philosophy behind the increase, USCIS is really embracing the ability to pay model, meaning those who are more capable of bearing the burden of fees pay more for services than those with less ability to pay. The agency's last attempt to raise fees under the Trump administration was very much focused on each applicant paying for the cost of adjudication of the benefit they were applying for, regardless of their ability to pay. USCIS isn't abandoning that beneficiary pays principle, but the overall shift to the ability to pay philosophy is why you will see much higher increases for businesses than, for example, for family-based petitions. In addition to the higher filing fees, USCIS is proposing a surcharge on employment-based petitions to fund the new regulation USCIS began implementing last year to reform asylum processing at the US-Mexico border. Unlike previous regulations, this one doesn't propose any big changes in immigration policy, agency processing, or the way you all submit petitions to the government. The focus is very much on adjusting the fee schedule because the agency is really still experiencing a financial deficit. Okay, so let's get into the actual numbers. As you will see, one of the changes USCIS is proposing is to charge different fees for different non-immigrant classifications. So there would no longer be one I-129 fee. Importantly, the agency is not proposing to separate the I-129 into different forms at this time, like they did under the last regulation. They may do that in the future, but it wouldn't be part of this fee rule. So that's important to know. You won't have to submit a different form. They're separating the fees. So first, USCIS proposes to significantly, as you can tell from the numbers on this slide, increase the base filing fees in these classifications. One of the biggest jumps would be the H-1B registration fee, going from $10 to $215. On top of these higher base filing fees for each classification, USCIS is proposing this new asylum program fee of $600 per petition for the I-129 and the I-140. This includes initial petitions and renewals. So it goes without saying that this is a huge increase in government filing fees. And so with all of that combined, we end up with the percentage increases you see at the bottom of the slide. I mentioned that USCIS isn't making any major process changes, but there is one to be aware of. The agency has proposed to give itself a bit more time for processing premium processing cases. So they're proposing to turn that clock into 15 business days instead of 15 calendar days. So again, no difference in terms of how you submit to the government, but they are wanting to give themselves more time. Now I'll turn it over to Amy to talk about what this means for your companies.
Yeah, some sort of maybe concerning changes there. If you're in the business of filing fees. So I think the question that a lot of you are going to have is, how do I process this? What do I need to do so that I can plan for these changes? So I think there are a few different approaches that you can take, starting with the most straightforward. This is not a flat rate change. So this is not something where they've just increased fees across the board by 30%, something like this. So depending on how your program is structured and what types of petitions you're having to file, you'll see different effects. So it's not necessarily a very straightforward calculation. However, one of the ways that you can at least get sort of a benchmark for how this will impact your program is very simply to double the fees that you spent last year, the filing fees. So that will give you at least a sort of a starting point. When you're ready to get just a little bit more detailed with it, we encourage you to look at the fee calculator that we have created at BAL, which you can see a screenshot here that gives you an idea. So essentially, you're able to go in and for each type of case, you can enter the number that you filed last year, say, and it will calculate for you immediately what these fee changes, if they were to go through exactly as written right now, what they would look like for you. And it gives you a full tally of the increase that you can expect. So very quick, very easy. When you're ready to get even a little more advanced with that, you can do sort of the more advanced version of using the calculator, which would be to maybe do some pre-reporting about what your program has looked like over the last few years, and thinking ahead kind of what you anticipate it's going to look like. And maybe even once you're looking at how the numbers are shifting for you, if you need to tweak the numbers of cases that you intend to file. So maybe you will want to file fewer of one fewer perms or fewer of one type of green card or another. So this lets you do that kind of adjusting and look at different scenarios as well. One of the things that you're also going to want to take into account that is a little difficult to do right now because we don't quite have full information is you're going to want to take into account when this is going to go into effect. And we'll talk a little bit more about that in a few minutes. But for the moment, let's look at a little bit about how we got here. So turning to our industry experts who have been leaders in the agency that we're talking about here, Lyndon, what did we do to get here?
Well, when you say get here, I guess you mean how do we arrive at the point where these fee increases are really, jaw-dropping? And it's something I know for all of us, we anticipated significant numbers. Everyone inside the administration that we were talking to were preparing us for bigger numbers. Even when I read the regulation the first time, I was like, okay, they're big numbers. But when I went to prepare this chart and saw those, it's staggering. So there's, a few factors of how we got here, and I'll cover some, and Kelly's going to chime in a bit with really the meat of it. But, the one factor is just length of time. Right, it's a big agency, so it's 19,000 employees, 200 offices worldwide, and pretty much all of their funding comes through these fees. They get a very small percentage, less than 4% of their funding comes from congressional appropriations. When it does come from Congress, more often than not, it's directed funds, so they can't use it. They don't have flexibility to use it in any which way they want. I mean, you can jump through some hoops and kind of move things around, but that's very difficult. Whereas the fees that all of you pay for your applications, almost all of them go into the examinations fee account. And so there's a lot more flexibility on how they use that. But they're supposed to, so backing on that timeline, they're supposed to do this every couple of years. I was actually general counsel of the agency when they did a very large, very controversial fee increase in 2007. A lot of litigation surrounding that fee regulation, and those numbers are nothing compared to what this one is. But what happened was it lagged. They started to get behind the curve on raising fees. And then we saw really in the past 10 years, a rapid acceleration of new requirements coming into immigration applications. We're going to talk a little bit more about that, but the form length, the types of questions that were being asked, FD&S operations, site visits, the level of scrutiny and inquiry, obviously behind the curtain, the security checks and things like that were all increasing during this time period, but they weren't keeping their fees going up every 2 years as they were supposed to do it. And so we have not seen a fee increase since 2016. There was an effort a few years ago, as Amy and Eileen mentioned, and that failed because they went for too much from a policy perspective, and so it collapsed. But we're now, 7 years, and it might very well be 8 years since the last fee increase. And so that's the primary, there's few factors on there. So what does it mean? I mean, they are facing a $1.8 billion shortfall in the upcoming year. And I just want to emphasize that's a shortfall. So that's not, hey, if we want to get down to really fast processing times and a really exceptional experience and kind of bring us up to a private sector experience, that's actually just a shortfall to keep doing what they're doing right now. And I imagine most of you have opinions on how well they're doing what they're doing right now. So this shortfall right now is just staggering. And, to their credit, I think we really do have to give credit to Director Jadu that they are starting the process for the first time ever and looking at the length of the forms, looking at all the layers that were added on, trying to find some efficiencies with things like biometrics. I know some outside groups are going to try and help them in terms of identifying, and we've had a number of conversations with them to identify opportunities to be more efficient, but it's not going to make up $1.8 billion. And so what they're really looking for at the end of the day is to be able to hire more staff. So this fee rule is not going primarily towards a technological revolution. It's not going to rapidly accelerate the transition to online filing or anything like that, those big levers that they need to pull. Instead, we're talking about 7,700 staff, and I didn't crunch the numbers, but going up from 19,000 to 26,700 would be a substantial increase on a staffing level. So I'm going to pause there for a second and let Kelly talk about the other half of this, of what the driver is on the fee rule, which is going to be a little bit more controversial.
Yeah, thanks, Lyndon. And I think, as you said, this is kind of like that second half big driver, and certainly in the last 2 years, even a bigger driver, right? So it's the humanitarian programs. And, for those of you who are unfamiliar with the fee structures in the humanitarian areas, generally those that apply for asylum and those that participate in the refugee program. So those refugees coming from outside the United States into the US, and then of course the asylum program, which is those refugees that are here asking for relief from having to go back to their home country. Those processes do not have filing fees. And so, 7, 8 years ago, and probably up through the middle part of the Trump administration, those application types were large. I mean, they had a good, amount of applications that they would accept every year. But I think all of us has seen in these last 3 to 4 years that certain growth of those asylum cases, right? So especially down at the southern border, the volume of cases that were coming in on the asylum program. And even though the refugee program was put on hold for a few years under the Trump administration, the numbers there, 125,000 refugees a year needing to come through that program. Again, that all needs to be staffed and processed. And that whole process is done without any fee on the application. And so taking a look at just those programs alone and the numbers of increase in those programs, now, in this last year and a half, we've got additional programs like the Uniting for Ukraine, the Operations Ally Welcome for the Afghan population. And now, most recently, we've got the Cuban, Haitian, Venezuelans, and Nicaraguan parole cases. And while those parole cases require a sponsor, there is no fee for USCIS to look at that application. So the I-134A doesn't require a fee. So with all of that being said, their workload continues to get larger in these humanitarian spaces, but they're not actually getting a fee for all the work that they're doing. So as Eileen had mentioned earlier, that's where we turn to, the ability to pay. So I think we're seeing in this fee rule, significant increases to help fund some of these humanitarian programs because of the volume that they're seeing and the need for staff to get the backlogs in order in those areas as well. In addition to the fact that, we have signed accords and, we have an obligation to help these folks, right? So I think we can all agree that we want to participate in this, but I think you're seeing USCIS really struggle with who pays for that. If Congress isn't going to pay for it through an appropriations, then how do we pay to really participate and really make sure that we're out there in that humanitarian space and be able to balance the need to have these programs, but how are we going to get the funding to get them done? So I think that's really where you're seeing that struggle in terms of where they can get the money and who's going to end up paying for that.
And I kind of want to share a bit of editorial on that as well, but also provide a framework for what I think many of y'all are going to have to navigate inside your organizations. And maybe, Amy, if you could go back to the chart that shows the different fees. I'm going to go off script here for a few minutes. So what they did in this regulation that's never been done before, as Kelly mentioned, is they've broken out a new asylum program fee. That's that blue box right there. Now, forever, for years and decades, since they've been doing fees, they have been imposing the asylum program costs and other program costs for people who can't pay writ large across the rest of the applications, family-based, employment-based. And they did it, kind of behind the scenes, right? They didn't define an exact number that an H-1B applicant was going to pay. It was kind of all done in the wash under the overall sentiment of, as Kelly mentioned, it's kind of like your taxes. You don't see exactly where they go, but you support these programs. It's now reached that level. It's an interesting strategic move where they are now breaking it out into a specific amount. And not only is it a specific amount, they've said that amount is necessary to implement the new asylum changes at the southern border. So they're kind of tying business to carrying the load to implement faster processing of asylum applications on the southern border. And they've done a designated amount and they've broken it out as a standalone application fee. So a couple thoughts on that. I mean, one, let's just talk about, one is a strategic question that they are being evasive on, was did they break that out as a separate fee because they think it might go down or it might even get struck down in litigation, and they wanted to kind of create a standalone target so that the rest of the regulation didn't collapse or get hung up in litigation. And there's actually what we call severability language in the regulation, that if that provision gets struck, the rest of the regulation can survive. So, the lawyer in me, former agency lawyer, Kelly is as well, we're thinking there's definitely a little bit of a litigation strategy there of breaking that apart. But there's also just an optics question that they wanted to emphasize, that ability to pay versus beneficiary pays, that theme, which is we think business can carry this load and we're not going to be shy. And we're going to say the quiet part out loud about that new fee. And that's the dovetail then into the challenge that you're going to have to face as you go brief your stakeholders. And we're going to get more into the stakeholder conversation. But, I think it goes without saying, on a personal level, myself, I grew up with a refugee in my house as a child. Like we had a refugee live with us. Our firm is a heavy sponsor of refugee sponsorship, both financially and through our work and service organizations and contributions. But the ultimate decision, so if you had to ask us whether this is worth it, I think we would, we're somewhat biased on that. But if we have to advise a client and a company, particularly right now with a downturn in the economy, when everyone's looking at budgets carefully, if you had to go brief someone about the financial impact of this regulation, it's reasonable and fair that the business interests are going to have questions about whether this is appropriate, whether that should actually, as Kelly mentioned, be a congressional amount. So you're going to get, when you go send this chart forward, it's very reasonable that your business unit's going to say, well, hang on a second, why is our company picking up these tabs? Why shouldn't all Americans pick that up through a congressional appropriation? Obviously, I actually do agree with that as well. And so it's going to be something that you have to navigate with the business about whether that's appropriate. And from a timeline perspective, oh, sorry, Kelly, it looks like you can jump in.
No, finish your thought. And then I just want to, because I think this dovetails into some of the questions we're getting in the chat. So I just want to address those quickly.
All right, I'll get off my, but like when you go in to talk to the business, I think this is an issue that is sensitive, right? Because people are sensitive about saying we should not pay for asylum processing, but you do need to be prepared. And that's why we're emphasizing it, break it down, that they know that the agency elected to make this an issue. It's a huge part of the fees that would be imposed upon your company. There's going to be mixed reactions about it. And the likelihood of Congress bailing you out in the next year is probably 0%. So it's just unlikely to happen. And so the agency is going to have to confront this question over the next year. So Kelly, I'll turn back to you to field some of these questions.
Yeah. So one of the questions that's coming in through the chat is, so is this $600 asylum program fee on top of the $780 increase, right? On, like, let's say the H-1B petition. And the answer to that would be yes. So you'd have the $780 plus the $600. And then, of course, any other like premium processing or attorney's fees or whatever else that goes along with that petition. So yes, that we're looking at not only an increase in the price of the H-1B cost, but then this asylum program fee as well.
And also to clarify, it would be on every single petition, including every extension and
yes. So yeah, as of right now, since the wording in the proposed rule says per petition, I think we can only assume that it's going to be not only for new filings, but also for extensions or change of employer, any one of those I-129 petitions. So again, all ways that we should be thinking, and we'll talk about this in the next couple of slides, but how can we comment back to USCIS in terms of what we think would be reasonable in this space, right? So, but knowing where you're at in all of those, and then when you're using our calculator to punch in those costs, you would definitely need to be including that additional fee. And then another question was on DACA in terms of the $600 per petition cost. As far as I'm aware, DACA already has fees that are included. So my understanding is DACA, is this asylum program fee would not be for DACA applications. It's only for the asylum, the I-589 application that these fees would go towards. So yes, so I think that's just a little clarification for all the questions that were coming in. So hopefully we covered that. And as far as we know, there would not be necessarily an end date on this asylum program fee either. It would continue. So I think to your point, whoever asked that question is, if the issue at the border ends up getting controlled and we find something where, you know, we're not having that issue at the southern border anymore, would this fee then continue to move forward? I think we can only assume it would. As a previous government employee, once the government starts taking the money, it's pretty hard for that to be shut off. So I think if they get accustomed to that $600 fee, they would probably most likely continue to carry it forward. So anyway, so I know we've got a lot yet to talk about and more hands-on for you all. So I'll pass it back to Amy. But just wanted to answer some of those questions for everybody.
Yeah, and let me chime in just looking at these questions. I mean, I think we have successfully gotten everyone's attention that these fees are substantial. And like I said, I personally went through that process as I put them on this chart and said, oh my goodness. And so what we are going to do, we're going to turn shortly to the time frame for when they will go into effect, including whether they go into effect for this year and the likelihood of them changing. So sit tight. Right now, there's, you know, if you still have questions coming in about the specific fees and how they apply, but as we mentioned, there's separate filing fee costs and now this new asylum program fee costs. And when you look at this chart, the total percents on the bottom left are the total percent increase that you would see for USCIS fees out of these two per petition.
And I just wanted to mention really quickly too, that the calculator tool that we have does include that $600 fee in the calculation. So if you, let me go back to that slide for just a moment. So when you are entering your fees in here, it's a little small to see on the slide at this moment, but it's, it does show you the current fees and then the proposed fees, and the proposed fees for each of those petitions that would include the asylum fee. It's included in that count. So when you're doing your calculations, it is right there, easy for you to see. So with that, thinking ahead a little bit about all of these changes and what these might mean for a lot of the companies that you all are working for. so I'll kind of pose this to all of you. How are we gathering information, kind of writ large, to help businesses make these decisions about planning? And are there any changes that we can anticipate, and so that will help us with that planning?
Well, I'll start off just on the advocacy front. These regulatory processes have kind of a life cycle, and right now, some companies are deep into this, and already done the analysis far along. We'll talk about that. But right now, I would say the coalitions tend to lag behind the company analysis. So the coalitions that we serve as counsel to, and we serve as counsel to a number of them, they are gathering feedback from companies. And as they get that feedback, so again, judging from the reactions, if the feedback is this is too much, this is too high, fill in the blank, the coalitions are going to start to factor that in. And the comments, the written comments, are due, Eileen, I'm kind of looking at you for the exact date.
March 6th.
March 6th, okay. So it's not a lot of time. That's going to come up pretty quickly. So we're at the end of January already. So about 4 weeks from now, I think, is when there'll be a focusing moment from an advocacy standpoint. As we look ahead, I do anticipate coalitions are going to be at different places on the strength of their tone when they give that feedback to the government. I think everyone's going to have concerns about the increases. They're going to obviously point out the failure of the agency to deal with processing problems and those issues. But how strongly they push back and then potentially turn to litigation, I want to get Kelly's thoughts on that. I think you could see differences of opinion in the same way I flagged that if you go talk to your stakeholders internally about these fees and whether business should pick it up, I think you're going to get differing views from different individuals within your organizations. Kelly, litigation perspective, you've already been talking to some folks about that.
Yeah. So, as we all know, and we mentioned earlier, the fee rule that was proposed under the Trump administration was due to go into effect in 2020, was stopped based upon litigation, and there was an injunction that stopped that rule from being affected. So, or enacted, sorry. And we do know that they're on that front, and Lyndon, to your point, in terms of the asylum fee being rolled into the overall, the fee itself. So basically what the Trump administration was doing on the asylum front was requiring the applicants to actually pay for that fee. And the justification for it was to prevent frivolous filings, which I thought was very interesting, but nonetheless. And so that was just one of, they were looking at each of the fees, but I think where it differs this time is one of the things that Judge White had indicated in the fee rule proposal for the Trump administration is they didn't provide the data and the statistics behind the reasoning of why the fees needed to be increased, right? So looking at this rule and how many 400 and some pages that it was, I think we saw the Biden administration now taking a more detailed approach to outlining why the fees need to increase in the way that they do. We may have debate about the way that they're processing and the amount of time it takes for them to process. And why, some of the requirements that they listed in the proposed rule, but nonetheless, they've provided more information. So I think, as Lyndon was saying, I think they took a more strategic approach in this rule to hope that they would have a better argument on the litigation side. And so, especially since we anticipate if there is any litigation, it may really come from more small businesses who will certainly see that greater impact, startups or consultancy companies who, really utilize high volumes of these different application types. perhaps, looking at universities who can certainly be impacted. So I think, there's definitely that tone there. I think people are certainly looking at, what's possible in terms of, fighting back. But again, to everybody's point, it's really going to depend upon what the final rule actually says. So I think that's why comments are going to be super important in terms of helping shape what it is that we think is more reasonable. They need the fees. I mean, they need the fees, but let's make them reasonable, right? So I think that's kind of going to be the focus. And any litigation will also be looking at what is the reasonableness of the fees and what is the data to support why USCIS is doing what they're doing. So we'll see what happens, but I would anticipate certainly everybody looking at litigation to stop it if we all believe that the final rule is still really going to impact without justification as to why they need the fees that they are requesting.
Yeah. And I'll throw in, two factors. One question we're often asked is, well, would they win? People are only going to sue if they can win. And that's different in a fee context situation, because there might be parties who want to file a lawsuit because they've done the math and their attorney fees to file that lawsuit will be lower than the regulation itself. Stated another way, they can in essence just buy time and push the implementation date off, even if they feel like they may not ultimately win on a litigation perspective. So for that reason alone, I think we are very early in the process, but thinking litigation is fairly likely. And as Kelly mentioned, there are groups who will be affected more than others and may not have the deep pockets or the resources to be able to meet it, in which case their back might be against the wall to force that timeline. I don't know if this is the right time before we get into our crystal ball on timeframes, but I'm curious to hear Kelly's thoughts on the likelihood of the substance changing and the fee amounts changing as it goes through this rule process. That used to be fairly common back in the old days, and then it kind of went away and no one ever wanted to admit they did anything wrong, and they would hold their fire. It seems like they might be signaling a willingness in this regulation.
Yeah, I agree. I really do. I mean, I think the way that they separated it out and, to the extent that they tried justifying as much as they could with data, I do think that they were certainly anticipating pushback. I mean, they saw the pushback in the Trump administration in terms of the fees, and maybe for different reasons with that fee rule than this one, but we're still seeing significant increases in the costs. And again, we've all evaluated their data. It does, I understand where they're coming from. And as you had said, all these different additional steps that have been put into place. But we do still kind of have some concern about why the fee is, 140% increase, right? Even with the length of time that's gone by. So I agree. I do think that they're open. And again, that's why commenting, really looking at your numbers, and please use our calculator, use those numbers, use that calculator to find those numbers, get that data, and then consider whether you're going to want to comment and how we would want to comment back. And as Lyndon said, we are running out of time. That deadline will be coming faster than I think we all anticipate. But at the end of the day, I do think we have some room to try to craft what works for everybody, or what appears to be reasonable for everybody in this space.
And Kelly, both you and Lyndon have mentioned the comments. And for people who are newer to this process of kind of how the regulation moves through the administrative process, maybe could you explain a little bit about what you mean by these comments?
Sure. Or Eileen, do you want to jump in on that? Because Eileen's our big point of contact she's
Perfect.
been awesome on that. Yep.
Yeah, so right now they're in a 60-day public comment period, which means literally any member of the public can log into the portal on regulations.gov and submit a comment to the government. And then, so they're accepting them until March 6th. And then at that point, they are required to review all of the comments they receive on a proposed regulation and consider them in formulating a final rule. So I think that's really important to understand in the context of the time frame of this. There was one question about whether the higher registration fee will be in effect this March, and that is a definite no, because unless there's no way they're going to go through all the comments and finalize a rule within like 2 weeks. So we're still very early in the process, and they've certainly been saying they want comments and they do want feedback. And so, as Kelly was saying, they are open to reevaluating these numbers. And I think one of the major themes, TBD on how hard the coalitions are going to push back on some of these fees, but one of the major themes is going to be, okay, we understand that fees need to go up. We want the agency to be functioning and healthy financially, but we're not happy about paying higher fees for the same service levels. So we expect USCIS to be transparent about how they're using these funds to improve case processing and restore reasonable processing times.
So thinking about the comments themselves, do we have any suggestions for people about what to write or how to submit those?
Yeah, I think we're going to talk a little bit about our approach and community. Many of you will break it out in two different things. Many of you can submit comments on your own. And if you have questions about that, I would ping Eileen directly. Many of you are part of coalitions that will be submitting comments and drafting it on their own or hiring other people to draft them. And you can work through those coalitions. And then BAL community and BAL, we're likely to submit our own and coordinate some benchmarking and some feedback to the government. And we're going to talk in a few minutes about how you can participate in that.
But that would be one, as Lyndon was saying with the coalitions, it's really important for companies to be crunching their own numbers and figuring out the impact so that they can weigh in to whatever groups they're a part of that might submit comments so that they can be informed in what they're saying to the government.
Perfect. So thinking, sort of from an action mindset, if we think about a spectrum kind of from just looking at the rule and understanding it to kind of an opposite end of the spectrum where we're immediately getting ready to file litigation, where should the people who are on this call fall on that spectrum right now?
Well, I don't know if it's the answer folks want to hear right now, but unfortunately, I think you we're far enough into this process now, and the timelines are short enough, the stakes are high enough, that action is probably warranted. Now, what do I mean by that is, it's an issue we've been monitoring for well over a year now, a couple of years. We've been monitoring and gathering information and providing feedback to the government. The regulation is out now, and as we've really emphasized, it's important to analyze it and understand it. And what you'll want to start doing, depending on those tiers, right? You might just need a back of the napkin. Hey, here's a quick number. That might be your culture or the bandwidth of the people that you're going to talk to. Just give me a top line estimate. But others are going to say, tell us what this really means for your program, both financially. It might also just change your overall flow of your workforce. If USCIS fees go really high, there was a question of State Department fees for visa processing. It's a great question. There's actually a separate State Department fee rule that was released just after the USCIS one. It does not have as substantial a proposed change because it's just affecting the State Department fees, and we'll be covering that in a little bit more depth. But it could affect. Bottom line is there will be some moderate increases in State Department visa fees, but nothing like this. So that could mean that you might elect to send more L1 travelers to the post than to file with USCIS. So the money might dictate your talent strategy and your mobility strategy. So you're going to start to get questions like that coming out of that analysis. And so if I would say, depending on the organization, but more likely than not, if I was sitting inside a company right now, I would be preparing to brief internal stakeholders, not as an alarm bell briefing, but as this is far enough along, it might change and we'll have some talking points for you shortly, but go ahead and start putting that information to them either in person or in some bullets transmitted to them. Might be some differing views on whether I'm leaning into that a little too aggressively. Callie, thoughts?
I think that's probably reasonable, but I just want to reassure people that it would be okay if you're still a little before the briefing stage and still figuring out what it means for your company.
Yeah, and I think, and there could be those of you who are like, look, I just don't, we're so under the water right now with everything else going on in the economy. I don't even want to freak out my chain of command at this point by like telling them that all these fees are going to go up without really knowing what's going to happen. So you could really just decide to just, keep it close hold to you until these fees actually seem like they're going to go into effect. As Eileen had said, March 6th is the deadline for the comment period, but we do know that, the agency will have to take another, 30 to 60, maybe even 90 days to review all of that. And then before they issue any final rule, that takes time to then, allow that final rule to go through all of its time frame before it becomes effective. So that's why we were saying, at the earliest, we're thinking, Q4 of this year, possibly even Q1 of 2024 is when anything would actually be enacted or hit your bottom line. So, I don't want to be, too relaxed on it, but, you could decide to take that depending upon how your company operates and how you want to handle the bad news necessarily.
We had a great question come in that I just saw, which, might take you to the ACT stage, which is, are companies going to increase their CAP registrations this year, both because of the CAP registration fee, but also in anticipation of the filing fees? And I just wanted to call out that question, get your thoughts on that, Kelly, Eileen.
It's possible.
Yeah, I mean, like you certainly could. I mean, I think the certainly if you've got the number of people that are, that are eligible and interested and you want to do that, certainly a strategy to look at. I mean, we'll see what the lottery comes back with. I mean, we know, the high number of cases that were submitted last year, which then generated a lower percentage rate of people being picked in the lottery. So, but certainly a strategy. But I think, again, you're still going to have to look beyond that, because when these when these become effective, the new fees, then you've got, it's still going to apply to your extensions, right? So either way, if you're increasing the number of foreign nationals that you're sponsoring, you're certainly going to have to be looking at those additional fees for each of those extensions, or even perm, if some of those folks would want a perm, I-140 process started for them. So I think all of that really comes into account when you're balancing out that strategy.
I think another point there. Oh, sorry, Lyndon.
Right.
But I think another consideration along those lines is that as Kelly said, the more registrations we have, the lower the selection rates. And so, one way to look at these increased fees, that substantial increase, especially in the registration fees, is that actually could be a very good thing for businesses, because what that's going to do is it's going to cut down on the number of people who are saying, hey, this is $10. Let me throw a name in, right? So it is quite possible, I think, that this year is going to be a high watermark for the number of registrations that we see, and that when these increases go into effect, that you might see that it deters some of those what the heck registrations, so that we're able to see the overall numbers come down and the overall selection rate go up, but remains to be seen.
I don't want to overcomplicate this because this is about the fee rule, but we also have other regulatory changes in the H-1B program that we're expecting to see proposed later this year that could even include some changes to the registration process. So it might look different next year for other reasons besides the fees.
Yeah, absolutely. Well, thinking about this question of getting ready to brief your companies, your higher ups, we do have some briefing points for you to sort of help you along in that process. We'll circulate these after the webinar. But when you're ready to get into that action mode and to start having those conversations, these will be a really good place for you to start. Not all of them may be applicable to you, but hopefully they'll provide you with kind of a basis for those conversations. All right.
And I
yeah.
would say, sorry, Amy, like looking
Go
at
ahead.
those, if we had a redo, and these things will evolve, but looking at the questions and the focus with the questions throughout today's session is why it's really helpful for us, to emphasize, the regular fees are going up a significant amount. And then there is a separate, just to clarify, it is a separate asylum processing fee, but has nothing to do whether your applicant is applying for asylum or not. It's a fee of $600 that you would pay with an H-1B or an L-1 or an I-140. So any of your I-129s or I-140s, and it would go to support the asylum program. Just like many of you know, there's a fraud detection fee and there's a worker training fee. Consider this now an asylum program support fee that would be separate. And you're probably going to get a lot of questions about that. So our next version of this might have that as well. But that's because it's a new thing. It's a new issue, and it's reasonable that people are going to have that question and need that clarified. Sorry, Amy, I thought I'd just jump in and emphasize that.
And then one other clarification, I think, does this also affect, these fees also affect the consular processing? And these fees will not be applicable to somebody picking up a visa with the State Department. But as Lyndon had mentioned, the State Department has also released their own fee increase proposed regulation. And so that right now is also being considered. But the good news on that front is it's not as significantly, the fee increase is not as significant as what we're seeing on the USCIS side. But certainly if folks are interested in talking more about that, we could certainly have that discussion on BAL community as well on the State Department fee increases as well. So certainly ping us and let us know if you'd be interested in chatting more about those fees as well, but they would be separate.
All right. Well, if you have questions, please continue to put those into the Q&A. We're very happy to continue answering those because we know that there are quite a few of them. But with that, I will turn it back to Lyndon to talk a little bit about what community is.
Yeah, it's been a few questions have kind of dovetailed with what the firm is doing with BAL community, and I'll say a couple words here. I mean, it sounds just its title. It's a community for in-house immigration professionals. You can go to the community website. We'll send everyone a link to where you can sign up for that. And what it is, it's an organization for in-house professionals that focuses heavily on benchmarking, best practices, and in situations like this, trading notes and feedback and perhaps providing comments back to the government related to policy initiatives. And so we're gonna, if this webinar has left you feeling like this topic is something that you want to follow more carefully, perhaps seeing what other coalitions are doing, hear from different speakers in greater depth about particular strategies, hear what other companies are doing on it. Community is an excellent smaller forum for that. And so we encourage everyone to sign up there to stay close to this issue and then be able to support each other. And then ideally help steer the government, provide some feedback and steer the government on that final outcome. So I know our team is geared up to send you some information via email afterwards. but it gives us a new platform and opportunity to be able to influence and help all of you do your jobs in terms of briefing stakeholders and sharing information.
Thanks, Lyndon. And thanks to our attendees for joining us for today's webinar. As a reminder, we would appreciate your feedback via the survey section at the right of your screen. Your feedback helps us shape our future webinars and give you exactly what you want to know. Be sure to watch your email for a link to the on-demand recording, PDF presentation, and link to our fee calculator. Thank you again, and have a great day.